conclusion of a secret court case could have wider implications for free speech here in Jersey. Well, that's what some are saying about the way that a law protecting the way that your data was used in an injunction against the former Health Minister, Stuart Syvret. No reporting of the case had been permitted, but the 4 people who we can't name for legal reasons took court action against Mr Syvret, and they were successful in securing the injunction. But with at least £387,000 worth of taxpayers' money spent on the case, what did it actually achieve? Our political reporter, Chris Rayner, has this report.
It's 6 o'clock on Monday, the 23rd of May. Good morning. This is Today with John Humphreys and Sarah Montague.
The news headlines this morning. The government's coming under pressure over privacy injunctions after a footballer said to have brought a gagging order was identified on the internet and in a Scottish newspaper. President Obama is on his way.
It was a couple of years ago that so-called super injunctions hit the headlines in the UK, with celebrities seeking gagging orders to keep their private lives secret. We may be spared a tabloid press with its stories about extramarital affairs of people in the public eye, but the nature of the allegations that led to the injunction in Jersey are of a far more serious nature. 4 people named on a blog site run by former politician Stuart Syvret took out the injunction using the data protection law. With proceedings held in secret, they wanted internet postings about them removed and not repeated. The case became notorious not only because it involved the Royal Court and Mr Syvret, but also because no one could talk about it and no one knew how much it was costing. Not even the person it was aimed at was aware at first he was being taken to court.
When this case first came to my attention, after the initial injunction had been decided in secret without my knowledge, and 2 officials came banging on my door delivering 2 huge file cases and telling me that I would be arrested and put in prison unless I basically agreed to a supposed court order that would effectively mean the end of journalism in Jersey. I wrote to the court at that point, pointing out the structural conflicts of interest that affect the judges and the court, and suggesting that I needed and wanted, as would any person, an Article 6 compliant hearing, one that meets the proper objective standards of the administration of justice.
He says that was ignored by the court, which carried on sitting and made its judgment in his absence. The court found each of the 4 had suffered substantial distress and damage by what had been written about them. One of them talked of how the accusations of serious criminal wrongdoing had caused damage to his business interests as well as to his health and reputation. While they may have got their injunction, it seems to have made little difference. Mr Syvret says it had only one purpose, and that's not to protect 4 individuals.
The real purpose of this action against me has been to essentially intimidate me and stop me from publishing evidence and examining in detail evidenced examples of many various gross failures by Jersey's public authorities, including plainly unlawful acts by public authorities. For example, various conspiracies to pervert the course of justice, various breaches of the Children Jersey Law 2002, various examples of misconduct in a public office. Now, these are evidenced facts, and it's a huge, huge problem for the Jersey oligarchy that I publish these facts, and I do so on an evidenced basis.
So if he's unwilling to take them down, what is the court doing about this? The judge, Commissioner Sir Charles Gray, said while Mr Syvret had persistently failed to comply, there was little he or others could do. The following is an extract from his judgment on breaches of the injunction.
As I believe, the representatives accept, albeit with reluctance, that there is little to be achieved by their committing further funds to the attempts which have been made to impress on Mr Syvret the need to obey court orders. Accordingly, I have decided, with some reluctance, that no further action should be taken.
The only way a contempt of court action could begin is if the 4 bring that to the attention of the court. Last week, some of the costs to the public of this legal action were revealed. The Chief Minister, Senator Ian Gores, took the unusual step of commenting on the work of the Data Protection Commissioner, but was only able to reveal what she'd spent on legal advice and not the sum spent in court. At £387,000 so far, others are asking for the full amount. Deputy Trevor Pittman, who's been raising issues about the justice system and the role of the media, says this is an attempt to shut down citizens' media commentators on the internet.
The cases have got nothing to do with each other. The only common denominator, obviously, Syvret's attacked them. It clearly should have been a libel case in every instance. So why was the data protection law used? None of us have been able to get answers as to why the data protection law was used. And when you look at the judgment, the implication would seem to be that the natural extension is, if I don't like something that you say about me on the radio, I can probably challenge you on it by this use of this law. And it might not be anything particularly bad that you've written about me.
A statement by the Data Protection Commissioner, Emma Martin, says the judgment by the Royal Court was clear and the 4 applicants were successful in winning the relief they were seeking. No further comment is being made. Part of Mrs Martin's statement is read by Claire Peters.
This has been a difficult, complex and long-running case which has taken a real personal toll on the applicants. We are all accountable for what we write and say in the online environment, and that accountability applies equally to those who claim journalistic status. They also have to face the legal consequences arising from the damage that they do and the lasting harm they can cause through their actions. This judgment shows clearly that the laws that protect us in our everyday life also extend online.
A statement released last week by the Chief Minister backed the actions of the Data Protection Commissioner in using the data protection law in this case. Despite what some are saying about it being an attack on journalism, the authorities say notice had to be served because the 4 had suffered significant distress. But without the offending postings being taken down, some are wondering what this was all about, including Deputy Pittman.
But what's up there and what's caused all the fuss is still going to be there. So what has it achieved? It's wasted, I will, as I say, put my reputation, it's wasted millions of pounds of taxpayers' money for nothing. The Chief Minister said 387,000. That's only the alleged legal advice to the Data Protection Office. And yet it's very funny when this has been running for several years. If you look through the accounts, there's no mention anywhere of costs of legal advice. So, you make of that what you will.
Stuart Syvret says he'll appeal and will try and take the case to the Privy Council. But he says even that body has failed to meet its duty to ensure the proper rule of law and the good administration of justice in Jersey.
That from our political reporter, Chris Rayner. So, the conclusion of a secret cause case that many are saying could cause wider implications for free speech here in the island. Well, that's what some are saying, but what do you think?